Hi there, welcome to our weekly immigration show. Today we're going to be talking about how to bring a family member to the United States with the most popular form to do that, which is Form I-130. We're going to talk about mistakes that are made, what you need to look out for, and how to succeed using this application. So stay tuned to watch this video to learn how to bring a family member to the United States. My name is Kaushik Ranchod. I've been practicing immigration law for over 20 years and I look forward to sharing that info to you now. All right, let's get started. While bringing family members to the United States can be a complex process, the I-130, also known as Petition for Alien Relative, provides a pathway for US citizens and lawful permanent residents to sponsor eligible family members. You might think, well, it's just filing the I-130 form, but there's more to it, and we're gonna go into that in this video. We're gonna talk about the supporting documentation, and sometimes it's what you don't know that could be the problem. So for instance, we had a client that hired us after they tried to file on their own, and what they didn't know was that they needed to also file the form I-130A. So this is an example of what you don't know that you don't know. Because that wasn't filed, the case was denied. So now the client has come to us to fix that problem, which we will by filing form I-290B and a supporting motion to remedy the problem. But of course, this is an added expense at added time. So if you can get it done initially, you won't have to worry about that. Now let's talk about who qualifies for the Form I-130. Form I-130 is known as a petition for alien relative, and it's the crucial form used by both US citizens and green card holders to establish a family relationship with an eligible relative who wants to get a green card. With the I-130, you're demonstrating that you have a real relationship with your relative. This form is vital if you're applying for a green card in the United States, which is adjustment of status, or if you're applying for an immigrant visa, which is where you're applying abroad. It's also the vital form for two main types of green cards based on family relationships, whether that be immediate relatives or family preference green cards. Immediate relative green cards are available for the following family relationships. That would be the spouse of a US citizen, the unmarried child under 21 years of age of a US citizen, or the parent of a US citizen who's at least 21 years old. Family preference green cards are available for the following family relationships: an unmarried adult child of a US citizen, the spouse, an unmarried child under 21 years of age of a US green card holder, an unmarried adult child age 21 or over of a US green card holder, married sons and daughters of a US citizen, and brothers and sisters of US citizens who are at least 21 years or older. Now, if you can demonstrate the relationship with your relative, that is one of the key components to getting your application approved. Once the petition is approved, your relative can usually apply to become a lawful permanent resident. If the prior date becomes available for family preference green cards, that's when you can apply for the green card. For immediate relatives, you can file a one-step application where you can file your I-130 and I-485 together. If your relative is already in the US and a visa is available, they may be able to get their green card by completing Form 485, known as Application to Register Permanent Residence or Adjust Status. Now, some relatives may have to wait until a visa number becomes available before they can apply for either 485 or a visa if they're outside the US. One important decision that you'll have to make when applying for the I-130 is to decide whether or not you're going to be applying for adjustment of status in the United States or for consular processing abroad, and you'll need to indicate that on the form. If your form I-130 is still being processed and you need to change your selection, you can contact USCIS. Now, what do you do if your application's already been approved and you need to change your selection? In this situation, you may need to file Form I-824. Just as important to know who can file for the I-130, you need to know who may not be able to file for the I-130. So I'm going to go through the list of who shouldn't file for the I-130. You cannot file for the I-130 with any of the following relatives: grandparents, grandchildren, nephews, nieces, uncles, aunts, cousins, or in-laws, an adoptive parent or adopted child, a step-parent or stepchild if the marriage establishing the step relationship took place after the child turned 18 years old, a spouse if both you and your spouse were not physically present at the marriage ceremony, a spouse if you acquired US green card through a previous marriage to a US citizen or green card holder, unless you are now a naturalized US citizen or have held a green card for at least 5 years. Any relative if the USCIS has determined that the marriage or attempted marriage was solely for immigration purposes. It's important to note that there may be exceptions to these exclusions. In certain situations, you may be able to submit an I-130 petition with additional supporting documentation. Now, let's talk about a very important aspect of filing the I-130, and that is having the appropriate documentation. First, you have to show that you have the right to file the I-130 petition, and then second, you need to show that you have the actual relationship to your relative. You'll usually be required to submit the following documents: proof that you're a US citizen or green card holder, proof that there's a legally recognized relationship between you and the person seeking the green card, evidence that the relationship between you and your relative is genuine, official documentation for any name changes for you or the person seeking a green card, and proof of nationality of the person applying for the green card. If you're missing any required documents, you may be able to submit alternative documents. This is also known as secondary evidence. This is often common for birth certificates. So for instance, Indians who may not be able to have access to birth certificates would require secondary evidence plus a statement from your government agency stating that you're not able to obtain the birth certificate. So you might be asking, what are some examples of secondary evidence? Some examples of secondary evidence are records like baptismal certificates, school records showing birth details, and written statements from relatives who can also confirm the facts of the birth. You should provide as much documentation as possible, and if you have this situation, you may want to consult with an immigration attorney to make sure that you provide the appropriate documentation to prevent delays in your case. Now, of course, when you're filing, you want to make sure that you overcome denial. So let's look at some ways to prevent possible denial. If you do not provide enough documentation or information, USCIS issues a request for evidence. And sometimes these requests for evidence can be random. With I-130 applications, usually it's for a specific reason. For instance, you don't have the appropriate documentation. It's important if you get a request for evidence that you respond to this adequately. You want to ensure that your supporting documents in the request for evidence are of high quality. Poor photocopies or untranslated foreign language documents can also lead to a denial. To file the I-130, you must be eligible and have the eligible family relationship, as we discussed earlier, with the beneficiary. Now, understanding the qualifying relationship is essential because they fall into either immediate relative or family preference categories. If adoptions and step relatives may make the process more complex, what can be challenging is it can be difficult if you're from certain countries to obtain the necessary documents because they may not be available. Failure to prove the petitioner's status is another reason for denial. Only US citizens, US nationals, or lawful permanent residents can file the I-130, so it's crucial to include proof of your status when submitting the petition. US citizens can provide naturalization certificates, birth certificates, certificate of citizenship, or your US passport to demonstrate that you are a US citizen. You might be thinking, well, they should have this on file. Well, they expect you to provide all of the information. They're not, even if they already have even a previous application, they're not going to go back and reference that to approve this specific case. They should, but they don't. Green card holders can provide a copy of their green card or other acceptable documents. Another reason is failure to prove the family relationship. Not only, of course, do you have to have the eligible family relationship, but you have to prove it. While some relationships are easy to prove, others are more challenging. For example, a child born out of wedlock may not have the father's name on the birth certificate. Step relationships could also require additional documentation to demonstrate the relationship as well. And then finally, the one that I dislike the most, which is USCIS mistakes. Unfortunately, USCIS can make mistakes that can lead to an unjustified denial. This is so frustrating and time-consuming for everyone that's involved. Now, you can't control USCIS's mistakes, but you can control what goes into your application to make sure that you have the most thorough application possible when filing. If your package is well organized, thorough, it minimizes chances of oversights on their end. Carefully following USCIS instructions, providing thorough documentation, responding promptly to any requests for evidence, and seeking legal assistance will help increase your chances for a successful I-130 application. I want to thank you for taking the time to watch this video. By watching this video, you're bettering yourself. By bettering yourself, you're bettering your family. And by bettering your family, you're bettering the world. Thank you. Bye for now.